Good morning. My name is Nick Richards, and welcome to Cross-Border Cannabis Issues. Thank you for joining us, and I guess good afternoon if it's afternoon where you're at today. I'm a partner at Green Spoon Martyr, and I've been helping cannabis companies solve tax problems for a number of years now after being an IRS trial attorney. I'm really excited about this panel today. One of my big topics that I deal with a lot is Section 280E, and really one of the hot things out there right now is mergers and acquisitions and going public in the cannabis space. And so that's what we're talking about today, and it couldn't be more timely. So I'm really excited to bring that to you. We've got some amazing professionals. They're gonna educate us on the process and some of the specifics about it. And before we kind of get going on it, I'd first like to thank our supporters, our tech folks here and our marketing folks out there in my staff, Ellen and Natalie and Cynthia. Thank you so much for pulling this together. Great work, all of you. And also thank you, Citron Cooperman, Heim Lance, MGO, Miller Thompson, Noth LPC, and also Green Spoon Martyr as well. Great firms doing great work in the cannabis space, and I am honored to bring us all together here today. So today we're talking cross-border cannabis issues, and our program consists of a couple different things. We've got our panelists have pre-recorded each of them a 30-minute session on a particular topic with a deeper dive. We'll kind of hit those a little bit today in our panel session, and then for further information, I encourage everyone to go ahead and go on to our respective firms' websites and check out the materials. I've watched them all. They are amazing, really good educators and professionals providing extremely good information. And so I learned a lot from watching it, and I would encourage everybody to do that. We'll go for about 45 minutes or so today, and then we'll take a 5, 7, 10-minute break, something like that, probably 5 minutes. And then we'll get back in and we'll finish off. The total program today is about 90 minutes. And I encourage people to use your question and answer function on your Zoom webinar browser there to ask questions if you have. I'm going to try to keep this kind of free flowing and conversational, and so hopefully we can have a really good discussion and learn a lot about going public and mergers and acquisitions, both in Canada and elsewhere as well. Some of our topics today, we're going to be talking about both hemp and marijuana. We're going to be talking about going public in Canada or forming companies in Canada and what might be appropriate about that. We're also going to talk about other foreign markets and how companies might expand into foreign markets. We'll talk a little bit about new Internal Revenue Code Section 471C in the context of getting bigger and going public and whether those are appropriate or not. We've got a segment on international tax and business structures, and that's kind of peppered a little bit throughout our presentation today. We got inbound and outbound transactions we'll be talking about, REITs, inversions, SPACs, all kinds of fun stuff. So let's get started. I'd like to introduce our experts. And first, I'd like to introduce Sanjay Agarwal. Sanjay is an international corporate tax partner and office manager of MGO Silicon Valley office. MGO is a big player in the cannabis space. They've been one of our tax partners in the industry for quite some time now. Sanjay has over a decade of international and corporate tax experience, and he's an expert in a number of areas, including international and corporate tax consulting, transfer pricing, M&A transactions, and advisory services. And he also serves as the overall business advisor to his clients. And Sanjay, I really got that impression when I watched your pre-recorded stuff that you're a guy that I would want to be consulting with every step along the way, from when I form my business to getting bigger and going public and wherever that was. Seems to me that you have really good information all along that process. And I really enjoyed your materials. Why don't you tell us a little bit, Sanjay, about kind of what you do and what your materials kind of covered?
Yeah, absolutely. No, and I appreciate that, Nick. Thank you. So I work primarily with multi-state operators, both in the cannabis space and in the CBD hemp space. And we have a dedicated cannabis tax team that works on a lot of areas, including, going public, what the special considerations are there, multi-state issues as companies are expanding beyond one state into numerous states. And we're obviously going to see more growth there as legalization occurs. And then also international as well. And we'll touch on this a little bit later, but not just for CBD hemp, but for cannabis operating companies. I mean, we're looking at things globally now, right? There's a huge opportunity in front of us. Whether or not we have legalization here in the U.S., the international opportunity is real, and I think a lot of multi-state operators are seizing that now. So that's pretty much what I do on a day-to-day basis. The video that's available touches specifically on CBD hemp. There's a lot more that we can do with CBD hemp now, including, selling across state lines and shipping and selling internationally. And so that's what the video touches on. And we try to not just focus on the tax considerations, because tax is really secondary there, but more on just the business considerations for a CBD hemp company based in the US that's looking to go global.
I thought it was great. I'm going to actually make sure that all of my CBD folks take a look at it, because I know they're all sort of thinking about those other markets, and it just was a really good sort of primer on what you should know and be thinking about as you're moving in that direction. So thank you for that, Sanjay.
Thanks, man.
We've also got, I'm going to go through and introduce to everybody, and then we'll kind of break it down a little bit, and we'll get into some of these topics a little deeper. Next on my list is Fred Corso. Fred is a member of the leadership team for his firm's international tax practice. He's located in the greater Boston area. He has 25 years of experience in this area. Fred, you're kind of a quiet guy, but you're a real powerhouse. I got to say, I'm starting to kind of realize that as we've been working together. And you've been working with multinational enterprises and venture capital and private equity funds, and everybody wants the money, right? And it seems to me that you've got a real good idea about that part of it, which is really exciting. Really look forward to hearing what you had to say today. I definitely watched your and James Guardiana's video, and it was really, really interesting. There's some complex concepts in there, right? And I want to watch it again and try to soak up a little bit more of it. But they are extremely important stuff in anybody that's looking on growing in the sector, in any business sector for that matter. And really appreciate what you were doing there. And so, Fred, why don't you tell us a little bit about your practice and yourself? Are you really a quiet guy, or am I just getting that on the video?
No, I think you have me pegged correctly. I tend to be one of the quieter people in the room, that's for sure, until you get me onto a topic that I like a lot. So international tax happens to be one of those. So I'm a partner in our international tax practice and part of our national international tax practice here at Citron Cooperman. We are one of the largest top 25 firms in the country. So we have cross-industry and cross-specialization practices. So I'm dedicated to international tax, global structuring, inbound and outbound. And one of my primary industries of focus, of course, that's why I'm here, is cannabis. But cross-border taxation, when you have to take into account principles that apply in the US and principles that apply in local country jurisdictions, and then overlay that with things like 280E, are remarkably complex. And if someone is trying to expand from the US out into a foreign jurisdiction through one form or another, the pitfalls are many. And I can only simply advise that it's best to have discussions early and often and consistently so that those pitfalls are not tripped.
No, people always sitting in audiences love it when attorneys and accountants tell people that they really need attorneys and accountants, right? But I'm sure all of us could tell all the stories about the cases and the clients that we got, halfway into the process when they didn't have those attorneys and accountants at the beginning, and the difficulty of those matters. So appreciate that, Fred. Any other little insight on that?
I have seen more things that have to be rectified in the course of my career. And I won't lie, they're often the most interesting things to deal with, but I would much rather be on the front end of that. And I think probably everyone on this panel would agree with that.
Yeah, certainly in my area, I deal with a lot of 280E and that those issues early on that a lot of people kind of, whatever, gosh, is it really real? Then and the chances they took early on tend to then become big issues later on in the game when they're trying to grow. And so that I agree. I think that's very interesting work is kind of resolving those early problems and how do you kind of get up to speed and move forward and help your clients succeed. So appreciate that. Thanks, Fred. Next up on my list is my partner, Jim Guardiana. I got to say, Jim been a tax expert for a long time. He's a guy I look to for advice, both professionally and with things about dealing with the firm and stuff like that. So I really appreciate Jim as an advisor in my practice. He has a really high level of understanding in mergers and acquisitions and the tax matters involving those. Both at one point sitting in a chair in Canada and now sitting here with us in New York at the Green Spoon Martyr office. So Jim, thanks so much. Jim, I don't see you on my panel here. I wonder if I just need to scroll over a bit. Are you there?
Are you talking to Jim?
Yes, Jim, talking to you.
I just lost sound for a while there, but I'm here.
Jim, that wasn't your Godfather impression there, was it? You talking to me? Jim, why don't you tell us a little bit about what you do and your background and stuff?
Well, I've been practicing about 50 years. Of the last 30, I would say it is virtually everything I do is cross-border. I do a lot of cross-border work with the M&A area. The countries I've worked with the most have been Canada. I was a partner in Canadian firms for about 17 years, principally Tories. And I also do a fair amount I have done a fair amount with Switzerland and the UK and other countries as well. Some in the Far East, but that's pretty much it. Most of the work I've done I've done a lot of transactional work, a lot of M&A, but a lot also in the tax planning area, executive comp, a lot of treaty work.
Great. Well, Jim's going to talk today about some tax aspects of cross-border transactions and maybe some help us out in understanding what REITs are and SPACs are and some of that stuff. So I'm really excited to hear from you on that stuff, Jim. Hey Sanjay, I heard Jim say Switzerland. And, when I was watching your materials, you were talking about some of the countries that where the CBD industry was growing. And I had thought that Switzerland was a place where there was quite a bit of CBD, but I don't recall if you mentioned that at all. Am I wrong on that?
So Switzerland is a prime market. It just doesn't have the history that some of the other markets have. I mean, believe it or not, Romania and Lithuania probably have the deepest history. Germany's up there too, and the Netherlands. I mean, those are probably the prime jurisdictions in the EU. And then you obviously have the UK as well. But Switzerland is an up and comer. We're actually setting up a Swiss structure now for a European-based CBDM company.
And are they also the 2%? I want to talk about that a little bit later, this 2%, 3% conundrum that we have out there.
That's my understanding.
Yeah.
That's my understanding, yes.
Yeah. Okay. Thank you. So next up, I've got Daniel Noth. Daniel is a trusted legal advisor who provides advice on U.S.-Canada cross-border capital markets, mergers and acquisitions, and corporate security transaction and regulatory compliance. Daniel's visiting us from Canada. He's one of our friends to the north of us. Great guy. Really enjoy working with Daniel. I did watch your webinar as well. I found it extremely informative on kind of just understanding what's out there and what we need to be concerned about and how to get there. and thought you were really engaging too, by the way. I appreciated your demeanor on the webinar. And maybe that's not something that us professionals are supposed to say, but I'll go ahead and say it anyway. Daniel advises Canadian and US and other foreign companies, also investment banks, in a wide range of US and Canada cross-border and domestic public and private equity and debt financing. Another money guy. That's really, I think, what this is all about. How do you get from company to money, right? So Daniel has a real insight on that. Daniel, thanks so much for joining us today. Why don't you tell us a little bit about your practice and what you've been doing?
Sure, no problem. Thank you, Nick. And thank you for the introduction. Funny enough, I actually started off as a Canadian lawyer and became a US lawyer early in my career. So I'm a dual call. But for the majority of my career, I've been a US corporate, securities transaction lawyer. By sitting in Toronto, I've had the unique experience of firstly dealing with many Canadian pubcos and dealing with the issues they face south of the border, whether they're raising capital, listing on an exchange, M&A transactions. And with the advent of cannabis in the past few years, you've had actually a lot of the reverse happening, where you have US cannabis private companies looking to go public in Canada on Canadian exchanges. And while there's a significant sort of legal process from the Canadian side, I've been involved in assisting in structuring from the US side, because while you think you might be going public in Canada, there are certain corporate and tax structuring things you need to consider when you're going public as a US company and on a Canadian exchange. But the majority of my practice is, quite frankly, limited to US corporate securities, capital raising transactions, whether you're a Canadian pubco, a US pubco, or a private entity. That's our sweet spot.
And Daniel, you and I met on the board of a Canadian cannabis company, and it occurs to me that do you do a bit of that work as well? Are you on the board of a number of companies, or is that just that one? Or
no, well, so we're on the board of Bang. We were on the board of Bang together. I'm still on the board of Bang. I do sit on a few boards and a number of some cannabis and some other sort of shell companies that are looking for transactions. So if anyone out there is watching and they're private looking to go public, we may have a vehicle for you, just putting it out there. But yes, I do that and sit on some boards. Because I think sorry, Nick, just say so Bang is, for example, a Canadian listed company, but it's a US operator. So, by being on the board, I'm able to sort of provide legal and strategic insight to them and how they operate and do's and don'ts and what we should or shouldn't be doing.
Great, good stuff. Thank you, Daniel. No, somebody had a question. They just popped up onto our chat. Thanks for letting us know you're out there. Asking about the materials, the pre-recorded materials. Those will be available after the webinar. All of you will get a link, and you can go in and watch the materials at your leisure. So you will all receive that, and thanks for looking for that. I really enjoyed them, so I would advise you all to check them out as well. Okay, so next up on my list is Robert Wesley, another partner of mine, another resource for me here at Green Spoon Martyr, and a gentleman that knows a lot about everything, I think. A person that along with him and Jim, I think they're kind of my guys that I go to when I got a question, and even I'll probably ask them about some of my concerns around the home as well pretty soon here as well. So thanks guys for being there for me, and Rob for tolerating some of my rookie questions. But Rob, you are a partner here at Green Spoon Martyr. You're part of the corporate and business practice group. You focus on international and domestic corporate transactions, strategic and structural advice, mergers and acquisitions, private equity joint ventures, financing, restructures, cross-border trade, and licensing transactions. And Rob, you're in our New York office. I know you have some new partners there. That office is growing, so that's exciting. Rob, why don't you let us know kind of what you do and what's going on in your practice?
Thanks, Nick. I'll try to be brief. I know that we want to get to the substance of our discussions. I've been an international cross-border M&A lawyer for a very long time, and I deal with jurisdictions all over the world. So one of the things I've become involved with is the international cannabis group that involves a lot of the experts in a variety of countries. I know Sanjay mentioned a number of the countries where cannabis is becoming a bigger part of the business. If people want to go into a particular jurisdiction, I'm somebody that can put them in touch with people in those particular countries. The focus now is between the United States and Canada. I did a number of cross-border M&A related things with Canadian public cannabis and hemp companies before the crash in late 2019, helping Americans to start distributing their products in Canada and dealing with a number of the regulatory issues that people don't remember. As Daniel noted, that if you're going public in Canada, you need not only to deal with the Canadian public laws, but also with a lot of the American securities issues that relate to what you're doing in Canada. So I hope we'll get a chance to get into that later on. Thanks.
Great. Thank you, Rob. Thank you. I've got two more introductions. Daniel Russell, thank you so much for joining us today. Daniel and I have been working together, and we've been having a really good time with some clients we have together. Daniel's going to talk to us about Section 471C. And Daniel, why don't you give us a couple minutes about your practice and what's going on with you?
Sure. Thank you, Nick. Once again, as you said, just want to thank everyone today for being here. A lot of great expertise on this panel, and I really appreciate Green Spoon Martyr, you guys taking the time and effort to put this together for all of the viewers out there. There's a lot of great information to share, and I'm excited to share my part of this. So my firm, Heim Lance, we're based in Annapolis, Maryland, and Alexandria, Virginia. We also have people in Lexington Park, Maryland, as well. And we serve companies out on the East Coast, primarily in Maryland and Virginia. And I'm excited to talk, as you said, Nick, about 471C and about the local Maryland area and what's going on here on the East Coast. So thanks again for the opportunity.
You bet, Daniel. I appreciated the local information that was in your pre-recorded segment, and also hearing from a real operator there in Maryland. I thought that was great. Last up, we got Lori Wilder. Lori is a partner at Miller Thompson. Lori, I'm going to do a little intro, and then I'm going to let you kind of go with your kind of overview that you're going to provide us to kind of get us into the meat of this. Okay. Lawrence Wilder focuses on representing public and private entrepreneurs and assisting them in successfully growing their business. I think he's sort of more than just a lawyer, right? He's an advisor, and he's somebody who's going to help you along the way in many ways. He handles all aspects of development curve, from initial equity funding to IPOs, and his merger and acquisition practices encompasses private and public M&A transactions. And he's a guy who has a lot of experience in this area. Oh, joining us from Toronto, is that right, Lori? Yeah, joining us for Toronto. And Lori, why don't you give us a little bit of a kind of a quick snippet on who you are and what you do, and then why don't you just go ahead and sort of launch into our overview, and I'll start you off with this question of why Canada?
Okay. Well, first of all, Nick, thanks so much to you and your excellent team at Green Spoon Martyr for taking the time to put this all together. It's been a lot of fun. A lot of the people on this panel I've been privileged to work with on transactions, and you're all terrific. And, as a Canadian lawyer, we have tons of these cross-border transactions, and without really good US cross-border counsel like you folks, and Daniel, who I've also dealt with on on many transactions, we would be lost. So, a shout out to all of you, because we really appreciate all the good work that you do. In terms of Miller Thompson, we're a large Canadian law firm that has offices across Canada, 13 offices, and we're a full service law firm. I personally head up our capital markets practice across the country, approximately 50 lawyers. We do all kinds of capital markets work, IPO, go public transactions, public M&A, all types of financing, equity, debt, SPACs, REITs, all the things that you've mentioned. So I'm very excited to hear all the different views that are going to be expressed today. In terms of why Canada, what happened when the Canadian federal government legalized marijuana use, it created what I call a legal arbitrage because, we had legalization. All of a sudden, we were able to start these companies, finance these companies. And in the United States, they didn't have that. And, it's been a slow evolution south of the border where state by state by state, it's becoming more and more permissive, but you still had the prohibition federally, which meant that you had all these companies that were growing and succeeding, but they couldn't open bank accounts and they couldn't raise money. So what to do? What to do was they looked north of the border and you had happy, welcoming Canadian investment bankers and lawyers who were only too happy to help them out, set up companies north of the border in our, in our legal system, which allowed, medicinal marijuana and recreational marijuana across the country. And there were no prohibitions on that. So, if you wanted to raise significant capital at a low cost, Canada was really a good option. And the other thing that's great about Canada is we're not as large as the US. So our capital markets generally are, our large cap would be your mid cap, and we're much smaller in terms of focus. The general focus of the market is on, mid and small cap, which fits perfectly with growing cannabis companies. And there's a whole ecosystem that has developed north of the border with our independent investment banks that have deep analyst coverage of all different aspects of cannabis. And so if you're a US cannabis company and you need money and you also want to do well as a public entity and have good analyst coverage and all the investment banking services that goes with that, Canada became the obvious place to go. So the first wave was Canadian companies going public. And then very quickly thereafter, we realized our market is really minuscule compared to the vast US market. So what happened, these multi-state operators were born that were financed in Canada. And, in the Canadian capital markets, because they're uniquely designed to raise capital quickly and inexpensively, just jumped into it. And the rest, as they say, is history. It's important to know that we have different exchanges up in Canada, and they have implications on how you can raise money if you're a U.S. cannabis company. The Toronto Stock Exchange very early on came to the conclusion that they could not finance U.S. cannabis companies because of the federal prohibition in the United States. They declined to go there. They were concerned about the legal risk. So they took themselves out of this unbelievable market. And the TSXV, which is the venture version of the Toronto Stock Exchange, they took themselves out of the market too. I'm sure they were, unhappy about it, but they did it. So necessity is the mother of invention. And so there was another small exchange that really wasn't doing much called the CSE, the Canadian Securities Exchange. And they became the go-to exchange for all US-based cannabis companies because they welcomed them with open arms, and they were a junior exchange. So if you were starting off small and hoping to grow large, that was the perfect spot for you. CSE. The other exchange that I'll mention, because it's an up and coming senior exchange, is called the NEO Exchange. The NEO Exchange welcomes US cannabis companies, and it has the advantage of being a senior exchange. So if you've grown beyond the confines of a relatively junior venture exchange, which would be the Canadian Securities Exchange, you graduate or you would start on the NEO. And they've had a lot of success recently with some very large cannabis-focused SPACs and cannabis-focused real estate REITs. So, with that, I hope I've done an okay job setting the table in terms of, why Canada, and then I'll let all my esteemed colleagues talk about how they can make deals easier and better.
Thank you. Thank you, Lori. I also enjoyed your partner, Devin Roth, and his participation in your video as well. Thanks, Devin, for that. I want to hear a little bit about plan and arrangement a little later, and you can, I know you educated me on that earlier today, so thanks for that. And I'd like to hear about that a little bit later. But first, I think just to give a kind of other kind of side of the map kind of perspective here, I'd like to hear from Sanjay and what else we can do to get in other countries and what other countries are out there besides Canada. Sanjay, when I was watching your materials, it wasn't so much about going public in those other countries as it was about selling products in those other countries. I wonder, I want to hear about that, but I wonder, is that right? I mean, if I wanted to sell products in Brazil, would I want to go public in Brazil, or would I still want to go public maybe in Canada?
Yeah, no, that's a great question, Nick. So, choice of jurisdiction for going public is generally something that the company can decide, right? But now in today's world, we're really looking at the SPACs and the investor groups that are driving that decision, right? So a lot of times the cannabis operating company is not going to be able to decide, and the choice is probably going to be Canada. But for a lot of our clients that are looking to go public in alternative jurisdictions and are looking at things more internationally, they're looking at Israel, for example, right? I mean, Israel is a huge up and coming market and is probably the country where a lot of the European-based cannabis companies that are up and coming are going to be going public themselves. So that is a viable option. And there's a lot of history there, not just on the cannabis side, but on the biotech side and the life sciences side as well. So we are hearing Israel pop up in a lot of these discussions. Also, we're looking at a lot of companies that are just looking at dual listings, right? They're looking at Canada and listing on the OTC here in the US. So that's also very popular as well. But to the extent that you have the ability to make the decision, I mean, my advice and what our firm will tell everyone is basically think it through, because you don't know what the future is going to hold, right? In terms of a future transaction. I mean, we have some clients now that went public in Canada that are looking to do deals with purely US based companies, okay, and not be public anymore. And having that Canadian holding company at the top is creating some issues, because we don't want to have a sandwich structure, and you have an exit tax coming out of Canada that you have to deal with, and you would have a similar tax in Israel too. So it requires thinking things through carefully and not just looking at the world that we're in now to go public and get that cash in a quick manner, but also where you might be in a few years, right? And you don't want to set up a structure or go public just to raise some capital now and have to deal with an exit tax in the future. So that's one thing. And then, the other thing that I would say is just on an expansion perspective, we're having discussions on a weekly basis with MSOs, and I Curaleaf really set this off with their huge acquisition. But all the MSOs, for the most part now, are looking at globalization, right? So they're looking at Latin America, they're looking at Europe, and a lot of people, like I had mentioned before, it's not banking off of just being, having federal legalization, but just looking at the global environment and the fact that cannabis is up and coming and it's going to be legal in a lot of countries, not just on the medical side, but on the recreational side, and the fact that the EU has even come out and is going to allow for cross-border transactions between EU countries, which would be very feasible and efficient to conduct. There's a huge market internationally, and that's not really dependent on where you're public, Nick, to answer the question. I mean, you could be public anywhere, but just recognizing that opportunity internationally and whether you want to expand organically and test the market, and that's something that I covered in the video, or if you want to just do an acquisition offshore or a combination of the two. I mean, there's a lot of options there, and that's why I think that it's important that that all the up and coming cannabis companies have these strategic discussions and loop in the appropriate advisors to really help them and guide them through this decision making process.
Sanjay, I thought it was really interesting. I liked the way in which you just laid out the different methods to grow in foreign jurisdictions, and I also liked the comments that you made at the end about some of the issues with different regulations in different countries, and 2% limitations in Europe versus 3% limitations here. It occurred to me that some of the very same issues are in that sort of the hemp sector as are in the marijuana sector, and same challenges in moving from state to state are out there and moving from country to country as well. And I guess that's just the sort of traits of a emerging industry that was once illegal. You know, I in the end is kind of where my head went. Sanjay, let me ask you this. We've got a question here that I think is right up your alley. So Mexico, our partners to the south, just legalized marijuana there. What do you think? What do you think is going to happen in Mexico? Is there going to be a distinction between marijuana and hemp? Where are we going?
Yeah, no, absolutely. And discussion that we're having with a lot of clients now is Mexico, everybody's just drooling over the cultivation opportunity there, right? I mean, cultivation in Mexico compared to the costs here in the US are going to be significantly lower. And so a lot of people are going to be looking at importing the cannabis from Mexico into the US. Obviously, we recognize the fact that with Mexico, the black market is still going to be huge, right? But from a commercial perspective, but just being able to import from Mexico into the US and sell is really going to, you know, improve the margin significantly on your cannabis transactions in the US. But that's a long ways away. I mean, you know, Mexico legalization is one thing, the ability to export out of Mexico is another, but then having the federal legalization here in the US is going to be the biggest barrier to doing that. So I think what we're going to see with Mexico is a lot of licensing arrangements. I think that's where the real money is. You know, once you know we're up and ready to go in Mexico, is that you're going to see a lot of licensing arrangements. There shouldn't be any hindrances on that, and that's going to be a way to really monetize the Mexico market in the U.S. You know, at least short term.
Sanjay, you talked about IP and how in some countries IP is owned by the country itself.
Right.
That's not Mexico? That's not one of our barriers there?
No, from my understanding, and I would, you know, recommend that somebody consult with a regulatory attorney on this matter, or an IP attorney. But my understanding is that's not the case in Mexico.
Mm-hmm.
So unlike some other jurisdictions in Latin America.
You were talking about some of those sort of holy grail things, you know, cross-border marijuana transactions and importing and exporting marijuana and all that kind of stuff. You think? I realize you were a little ways away from that, and you obviously said that as well. How far away you think we are? You think we're 10 years, 15 years, 5 years?
So I think there's a golden opportunity right now to make it happen. You know, if the Democrats lose control of the Senate in less than 2 years, then that opportunity goes away. So if it's going to happen, it's going to happen in the next 18 to 19 months. And that's really, you know, the only shot at this point. I mean, if they retain control of the Senate, then there's a chance it could happen in 2023 or 2024, but that's what we're keeping our eye on. But again, like I had mentioned before, I think that US based operating companies are recognizing that the international market is real and it doesn't depend on legalization here in the US. So you're going to see multi-state operators doing acquisitions internationally, expanding internationally, and so be it. I mean, you know, the only thing that they wouldn't be able to do is the cross-border transaction, the buy, sell, and moving the cannabis, you know, across country lines. But absent that, I mean, it's a huge opportunity.
Hey, Fred, what do you think? Do you think that U.S. cannabis companies have, you know, market share in foreign jurisdictions? Are the companies here? Do they have that kind of name recognition? Is that what do you think about that?
I think that some do. One of the things that was just touched upon was the idea of intellectual property and the use of that intellectual property outside of the United States. And we've been encountering situations whereby foreign corporations that have been organized by US shareholder companies have been formed by way of a contribution of territorial intellectual property rights with respect to certain intellectual property of the US company. So whether that be for exploitation, marketing, formulas and whatnot. And one of the components of that is things like brand name and the ability to use brand name in a particular foreign market. So I definitely think it has relevance in the foreign markets, and it seems that the companies feel so as well.
Daniel Nouth, I was going to ask you sort of the same question. What do you think about that?
Yeah, you know what's interesting actually, and by sitting on the board, I do like brand power, like it's particularly in Canada, and Lori could probably speak to this a bit more from the Canadian legal perspective, but the marketing rules around the products that are sold either in, the government regulated cannabis stores or online, the packaging is very bland, right? You're not allowed to sort of have logos or lots of information. So it's interesting because brand power does carry a lot, right? Like everything we see is that brand matters. And so it's interesting to me when we're entering another market or I see a cannabis issuer entering another market, it's always interesting to me sort of what the regulatory rules around packaging and advertising is, because how do you get the brand out there? Otherwise, how do you differentiate? Because, it's interesting. I found that cannabis users, whether they're buying the flower, they're buying edibles or they're buying gummies, whatever it may be, they're often looking for a specific brand. Like you have lots of companies out there who, they'll have all sorts of strains and they'll say it does this, that, and the next. But really what differentiates these companies, the brand and the brand power and how you get it out is what I found.
I guess focusing on that brand and building that brand, I hear again and again from professionals that that's really where the industry is right now. And I think that's really good advice. And that's kind of fun stuff, right? I mean, you get to be creative, you get to be a brand. I mean, I think that could be the fun part of being in business.
Yeah. And, Nick, the one thing I would say is, and again, if you're looking at expanding internationally, right, like sort of we've been having a discussion, I think part of your strategy should be, how do I build a brand in that international jurisdiction? Which jurisdiction do I go to first? Because what are the marketing rules like? And how can I get brand awareness? Because you wouldn't want to go somewhere where the marketing and packaging rules are very strict and you're not able to build brand awareness and you should kind of fall on your face. So I think there has to be a strategy around that.
And it seems like that's a real almost grassroots effort in a lot of ways in trying to build those brand strategies in other places. I guess we need influencers and whatnot in this day and age, huh? Hey, there's one more question here, and then we'll take our first or our one and only break. What will cross-border operations look like both pre and post U.S. federal legalization? Anybody want to take that one? I'll just sort of throw that out. What do you guys think?
So
is it going to look like the liquor industry?
Yeah. So the one thing that I would say is, and we touched on this previously, is that, before you have U.S. legalization at the federal level, you're confined, right? I mean, you can repatriate funds, generally speaking, between countries. So you could bring back the profits from, your European operations back to the U.S. But you're not able to enter into those cross-border transactions like we can with CBD hemp, where you're selling directly between the countries and importing and exporting. But in a post-legalization world in the U.S., that should change. We saw the U.S. adapt quickly after the Farm Bill to allow for CBD hemp both at the export and the import levels. So you would think that it would be the same for cannabis. And then that's going to open up the door huge in terms of being able to ship directly from the U.S. You look at edibles and other types of cannabis-related products that are manufactured here in the U.S., be able to ship that to Canada, being able to ship that to Europe or Asia. It'll open things up significantly. But it's not just one-sided. It's not just the U.S. I mean, the other country that's receiving or exporting has to also allow for it as well.
Hey, Lori, I saw you and Daniel both turn your mics off there for a minute. You know what I wanted to ask both of you guys is, can I, if I'm a marijuana company and I go public in Canada, can I export marijuana from Canada to other countries?
Well, I mean, it depends on the country. It's regulated heavily, and certain countries permit it. Others make it much more difficult. Obviously, into the United States is extremely, extremely difficult. I don't think you can do it.
Yeah.
And that's why, the multi-state operator was born, because they'd set up a holding company in Canada and operating companies in the United States that would carry on the business of the trade of cannabis. It's if just to answer the earlier question, if U.S. federal legalization happens, I think you see a sea change in corporate finance, because the competitive advantage that Canada has, other than being a first mover, which is relevant but not determinative, it's gone. And then the vast U.S. machine of capital raising is there, and you can get bank loans, you can get every investment bank in the States would jump on that bandwagon because it's very lucrative. And I just think things would change tremendously.
Yeah. People might want to come
So,
back.
this is Rob. This is Rob. I thought I just mentioned that a couple of things in terms of U.S. legalization, because I've been dealing with some of the people in the Senate, and as you know, we have a lobbying group in Washington that is focused particularly on the cannabis business. There is actually much more of an interest in some of the states that were very strongly, where their congressmen were very strongly opposed on moral grounds, the whole evangelical movement against cannabis. And I know I've learned recently that all of a sudden some of the congressmen from places like West Texas are hearing from their farmers that they'd much rather be raising cannabis-related products than cotton or something like that. And there may be a change actually on the Republican side as well. The other thing that I have to say to our Canadian friends is, of course, they should be giving as much money to the anti-legalization people as possible in order to keep the business up in Canada.
They're the ones that are behind it, huh? I know who's in it now.
Exactly.
Great, Robert. Well, guys, Daniel, you want to say something real quick before we go on break? You had your mic off there.
Yeah, sure. So I just wanted to touch on a point on this sort of U.S. federal legalization. If we're able to get there, there's obviously lots of moving parts, and it sounds like, if you can get Republicans moving in the right direction, it may not matter, to Sanjay's point, who controls the Senate, but we're kind of a far away from that. The other thing you might see, and just to go back to Lori's sort of opening remarks, is initially you had U.S. cannabis companies going public in Canada for a number of reasons. It was ripe at the right time. Canada was the first mover, legal. Companies are probably a little too small to go into NASDAQ or NYSE. NASDAQ or NYSE probably didn't want them at that point because of federally being scheduled. But I think if you see U.S. federal legalization, Canada may have a real problem because you may see a number of these companies, they certainly could dual list, but you may see a number of them delist and just move over to NASDAQ or NYSE because those guys are going to welcome them with open arms, right? I mean, so it'll be interesting to see what happens, whether these companies choose to stay as a foreign private issuer, which I think we'll touch on in Canada, or just make the move to being a domestic issuer, because that's the other problem, just to jump ahead a little bit, with being a domestic issuer, getting a registration statement cleared for a flower touching entity, would be difficult to get past the SEC. So it'll be interesting to see what happens.
Yeah. Thank you. Great. So we'll, when we come back, we'll go to Fred Corso. Fred will start us off with the discussion of guilty pastimes. Guilty principles and intellectual property. So see you guys on the other side of about 5 minutes or so. Thanks. Okay, we're back. And I just want to say before we get back into it, if you missed some parts of this and want to catch up on stuff, the pre-taped materials are a more in-depth dive into what we're talking about on this webinar today. So I would encourage you all to check that out. Okay, Fred, I think we left off with you. I was gonna. I've got written down here, guilty principles and IP that I kind of want to ask you to talk a little bit about. There might be some background you need to get us before we jump right into something called guilty principles, which I think is pretty complicated stuff. So I'll let you take it from there, and why don't you tee that up for us a little bit?
Sure. So earlier, Sanjay made mention of a structure called a sandwich structure. And for those who might not be familiar, the concept is that there is a foreign corporation that invests in a U.S. corporation that then in turn itself invests in a foreign corporation. So in a sandwich structure, we have something called inbound, investing into the United States, and then outbound, investing from the United States out into a foreign jurisdiction. And the principles that you just mentioned, Nick, so the GILTI, which stands for Global Intangible Low Taxed Income, which was something that was introduced as part of the 2017 Tax Act, is something that would apply in the context of outbound investment, where a domestic corporation makes an investment into a foreign corporation. That is something that we call a controlled foreign corporation. And importantly, these rules are really industry agnostic. They're US international tax rules that apply in general to outbound structures involving foreign corporations or controlled foreign corporations. And they're made all the more complicated by the fact that 280E exists. And there's a lot of question about how 280E applies in these contexts. But in the case of GILTI, or another provision is called Subpart F, there's this concept that foreign earnings of a controlled foreign corporation are subject to tax or includable in the taxable income of the US corporation on an annual basis, despite the fact that there has not been a repatriation of cash. So you can think of it like phantom income. And that's just, it's a concept that you have to know exists, because there is nothing intuitive about it. There is nothing intuitive about the rules and how they apply. There's nothing intuitive about the mechanics. So if you are making your first foray into outbound structuring and outbound business from the perspective of the US, this again is one of those pitfalls where there should be discussions very early on to understand what that might look like. In particular, there will be the same lingering questions about the ability to take deductions for purposes of determining that the amount that could be included in your taxable income. And one could find that one is whipsawed, subject to tax in a local jurisdiction and potentially subject to tax on the same income here in the United States without the benefit of a foreign tax credit. So these structures can become wildly inefficient very quickly, subject to authority and guidance that may come out over the course of time that provides more clarity or perhaps provides more favorable tax treatment.
Sounds like, boy, that would be another just horrible event for the cannabis industry if suddenly there was another imposition of 280E, right? It sounds to me like there would be sort of a double 280E potentially if you do this incorrectly.
Yes, that's right. And again, positions are not entirely clear. And Sanjay might comment, or Jim might comment. We've chatted about this a bit. There's certainly a lot of chatter amongst the practitioner community to see how far one might be able to go in terms of optimization of positions. But the language is, you look at 280E, it's a few sentences long. It's interestingly constructed. Some of the language can be read in different ways, but it's a challenge to deal with. And I'll add to that another thing that you mentioned a moment ago, going back to intellectual property. Again, in the instance of forming these entities, we are seeing the contribution of intellectual property rights in exchange for the ownership interests. And such a transaction often implicates a particular section as 367D, depending on the character of the intellectual property that's contributed. And this, again, can create phantom income in the United States through a mechanism of a deemed paid royalty owing from the controlled foreign corporation to the US. Again, something you have to know that it's there so that you can try to plan for it, because if you don't know that it's there, there's nothing intuitive about it.
And I guess if brands are everything, then IP is everything, right? Sanjay, I bet you have something to add to that, and then Rob, I bet you do too.
Yeah, so I think Fred is spot on with the technical analysis. I mean, we're definitely in agreement with that, and it's something that has to be monitored and vetted carefully when expanding internationally. The other thing you want to keep a lookout for too is potential tax reform. I mean, we're looking at potential tax reform potentially later this year, or early next year. The votes are already pretty much in place, and so we'll want to see how that plays out and how that shifts things. And if that's going to be more punitive, or if that will provide some relief even before we have any 280E related relief here in the US. So, and then the other thing I wanted to comment on is that, what we're seeing right now in terms of the international expansion for cannabis companies, if there's not the Curaleaf type acquisition, and maybe it's not of that magnitude, right? You're looking at setting up a subsidiary there or a branch office, and you're doing sales and marketing activities, right? You're looking at expanding your brand there locally. You're looking at sending corporate business development people there, or just hiring them out there outright to look at potential deals out there. And so that's a safer structure now. And a lot of these, international rules aren't really going to penalize you with that type of explorer soft launch type structure. But once you get into, sales transactions, or you get into the royalty payments, and everything that Fred just mentioned applies, and you're in that world.
Mhm. Is there a chance that 280E could go away through an international structure? Is that wishful thinking, or is there anyone out there thinking that might happen?
So I don't know, Fred, if you want to comment on that first.
I guess my comment or my reaction would be, until I see 280E go away, my answer is I don't see how it goes away for purposes of international tax at the moment.
Mhm.
Yeah, and I agree, because typically all the references out there when you look at the code and the regs, et cetera, is, you calculate foreign taxable income for U.S. tax purposes in accordance with U.S. tax principles, which would mean on its face that you would apply 280E to calculate what the U.S. taxable income is of a foreign corporation, right? So that's very punitive.
And one of the most interesting things that I've heard recently in terms of a potential approach, which still may not be beneficial for certain reasons, is a question of whether 280E would apply very strictly in the earnings and profits context, where that's an economic, it's a quasi-tax, quasi-economic context to determine dividend income. With these deemed income inclusions, they're calculated on a domestic principles basis, as Sanjay explained. So this is a tough one.
Yeah, Jim, what do you think? And then we've got a question I'd like to ask the panel. Jim, did you have something you want to add to that?
Yes, I do. I think it's an issue, and I think that I would ask this of both Sanjay and Fred. Is there anything definitive out there on this? And I don't think there is. I could see where if you're determining tax reserves and preparing returns, this at the very least would have to be flagged. And probably planning going forward, it's best to assume that maybe it's perhaps to assume the worst. But I do know that when I read the code, it uses the term trade or business. And it looks like you could have structures where you have a parent and a sub, and the parent is basically a holding company and maybe does certain management, financing, and so on. And I think if you start looking at the law on trade or business, particularly in the tax area and as opposed to the ERISA area, I think you could find support that the parent is not tainted by the activities of the sub. But there's nothing, I think what Sanjay and Fred are saying is certainly prudent.
Jim, I would encourage people to look at a case called alternative healthcare if they're thinking about that analysis on whether the parent is tainted by the sub. I think there's some good information in there. A lot of us are dealing with that case in entity structuring right now. So that certainly is one of those factors out there.
Right. That case, considers the idea of a kind of like a unitary business or
right.
Can you have trade or business in more? In other words, we're aware of the fact that for years we've looked at the situation for accounting purposes, 448 or 446 rather, where you could have two different trades or business for accounting purposes in one entity. But the big issue that's up today is, can you have one trade or business spread among a number of entities? And that goes to alternative and others as well.
Sanjay, you and being in California, you probably run into issues with that quite a bit, I would imagine.
Oh yeah, absolutely. I mean, that's one of the, and it could work to your advantage, right? It just depends on the tax rates. But unitary group is a real concept that is something that multi-state operators have to deal with and really work their way against if they're expanding into California. If you're in California, it may help you, like I said, but for companies that are, outside of California that are coming into California, the unitary group rules could create some tax implications that were not foreseen at the get-go with the expansion.
Rob, did you have something you wanted to add to this?
Yeah, I wanted to mention before we get off into all these wonderful tax issues that you tax guys like to talk about. For a lot of people that are still looking at the basics of making sure that their IP can be protected. First of all, I should mention that Justin McNaughton, who is our partner in our Nashville office, spends most of his time doing intellectual property protection for cannabis companies. And a lot of them think that once they've filed in the United States and they've dealt with the potential competing trademarks, that if they have overcome those things, they're done. They need to think about the fact that they've got to file internationally as well, in the EU, now separately in the UK, any place in Asia where they think they're going to sell their product. And because so much of their ability to build their business is going to be based on the success of their trademark, it's something that people like Justin McNaughton can be very helpful with.
For sure.
I also wanted to mention that you shouldn't assume that if an American company licenses its trademark overseas, that you don't have some potential issues and with regard to the taxation. And you should also look at the double tax treaties with those countries with regard to how they treat royalty income.
Thank you.
I would add, as to what Rob just said, you could look at treaties and you could find out that licensing income isn't taxed as property, as royalties, but as technical services. I mean, I've seen that.
Mm-hmm. And so the treaties that Jim just mentioned are the agreements between countries on various things, including tax matters. So that would always be a consideration that you'd want to take into account when moving into some of these other countries. Thanks for that, Jim. Hey, I want to go to Daniel. Daniel Noth, you sent me we've kind of been covering a lot of the stuff that's in your materials. And so I'm just going to kind of cut right to that question that you sent to me last night, which I don't even know what it means, to tell you the truth. What is FPI status, and why do we need to be concerned about that?
Yeah, so part of this whole conversation, we started with talking off about going public in Canada and why U.S. Canada. But I think this issue around FPI status, being a foreign private issuer, it matters for U.S. cannabis issuers, whether they're looking to go public in Canada, whether they're looking to go public in Europe somewhere, in any jurisdiction. And the reason is what they don't want to be is a U.S. domestic issuer. So the way the foreign private issuer test, the way it works under the Securities Act is that it's a two-part test. And the way it reads is, one, you have to be incorporated in a jurisdiction outside of the U.S., and I'll get to how that works with RTOs. But if more than 50% of your issued and outstanding voting stock is held by U.S. residents, you move to the second part of the test, which says if the majority of your executive officers and directors are U.S. persons, if your assets are principally in the U.S. or your business is principally run from the U.S. So if you trip the 50% and then any one of those three, you're going to be a U.S. domestic issuer, okay? And the reason that's important to avoid when going public is you don't want to have to register with the SEC. You don't want to be subject to SEC reporting and obligations, because when you go public in Canada or Switzerland or anywhere else, if you're considered a U.S. domestic company, it makes it really hard for you to raise capital and do other things, because every time you try to go and raise money, you'd have to register a registration statement with the SEC. You'd have to file proxy reports. You'd have to do all sorts of SEC domestic reporting obligations. When you're an FPI, you are excluded from most of the domestic reporting obligations. You may trip Exchange Act reporting and have to do some reporting, but you'd be reporting as a foreign private issuer, which is much easier to do than being domestic. So on the initial upfront structuring of these transactions, so whether you're looking to go public in Canada or any other jurisdiction, you really need to think about, and there's a well-worn structure for this in creating a dual share class structure, subordinate voting shares and multiple voting shares. And the whole purpose of that structure is meant to avoid that 50% threshold. Because if you're a US issuer, you are most definitely going to have the majority of your executive officers and directors in the US. Your business is going to be run from the US and your assets are going to be primarily in the US. So the whole way to manage that is managing that 50% threshold. I go into detail in it on my video, so I won't bore the whole panel and take up time here. But you manage that 50% threshold. There's a whole kind of cap structure that's built around for the go public when you sort of put your US operating entity as a subsidiary into your Canadian holding pubco or whatever jurisdiction it may be. What Nick, what you were asking about and what I was getting at was, you do that to go public, and that's great because you can manage it. It's static in time at the time of your RTO transaction. You know what the target looks like, you know what you look like, or the shell looks like. If there's a financing, you can manage all of those kind of pieces and manage that 50% threshold. What you cannot manage once you're public is secondary market trading. And I've had a number of clients now where, we're starting to trip or getting very close to tripping the 50% threshold. And there's just no way to structure around it, because if you get enough retail US interest, whether it's on the Canadian Securities Exchange or any other securities exchange, once you acquire a certain number of US holders in your subordinate common shares, you're going to trip that 50% threshold and you're going to be US domestic. And that creates a bunch of issues that need to be solved for. Whether you need to register, how do you raise capital, what do you do? From a tax perspective, I don't think, and the tax guys on here, I'm a securities guy, I know a little bit about the tax. Initially when the transactions are structured on the go public, you have 367, it's going to trigger a taxable event. There's no active trader business in the shell, so you need some way to get that rollover. It's structured as a 7874 so that the entity can be inverted. And the whole point is it's a US taxpayer. So from a tax perspective, you're always a US taxpayer. But from a securities perspective, that FPI status is very important. It's very important to manage.
I'll just add, this is Rob Wesley, that I agree entirely with Daniel. There are some things that are being tried in terms of trying to avoid going past that 50% threshold. And we'll have to talk about that offline afterwards, but there may be some new notions about dealing with that. Thanks.
Yeah, I'd love to, Robert.
Nick, you're on mute.
Thanks, Fred. Quiet guy, but when he speaks, it means something. So Lonnie, a CPA in California, who's a great person, asks, hey, if you're an FPI, can you trade on the New York Stock Exchange?
Yeah, so there's an FPI is just a status, and what it does is say, hey, are you US domestic, and what are your reporting obligations, or are you not? Could you trade on the New York Stock Exchange? Yes, but you would have to register with the SEC as a foreign private issuer, which is sort of a different topic of how registration occurs. The answer is yes, and there's not many that trade currently NYSE or NASDAQ. There are some, but unless the company is registered with the SEC and has a listing on either exchange, it's not going to be possible. Most of the cannabis guys actually, they have OTC listings for the most part, rather than NASDAQ or NYSE listings. So you can often find them on the OTC market.
Thank you. We got another question here. Theoretically, could a Mexican-American company operating under the Maquiladora system, I hope I got that right, export hemp-based products to the US for sale in the US market? A Maquiladora is a company with both a Mexican and US counterparts, importing all raw materials into Mexico and exporting all finished goods back into the US. Anybody got an idea on that one?
So that should generally work theoretically. I haven't explored that specific structure, that specific supply chain. The only reason why it wouldn't work are from a regulatory perspective, but from a tax perspective, that would work.
Anyone else got a comment on that? Jim, your mic is off. Did you want to add to that?
Well, I want to ask Daniel a question, a follow-up question.
Yeah.
How long has this 50% rule, this FPI rule, been around?
Look, the foreign private issuer test, it's rule 405. You can find 405 of the 33 Act. It's been around forever. And it's a way for the SEC, it's a way, I won't sort of read their mind, but it essentially puts you in a bucket, what your compliance with the 33 Act looks like. But for as long as I can remember,
Yeah, the reason why I mentioned it, one of the subjects I'm going to touch on is the intentional inversion of a Canadian company into a US company. I mean, I find this whole discussion, what you're talking about, fascinating. And what's very interesting is, I guess it was around 2014, some lawyers figured out that you could have a securities offering in Canada of interest in a Canadian entity. I think initially it was trusts. Now I think people are talking about LPs in Ontario. And that entity could, by reason of being inverted, because there's no significant operations in Canada, that entity would be treated as a US corporation for tax purposes. And that entity could elect to be treated as a REIT under US tax law. I think originally it was big in, it wasn't cannabis, although we have a cannabis REIT that I'm going to talk about in a moment. But it was big in student housing and in other rental areas. And the big thing that was people were saying about this device is, it's great, you avoid registering, you can have a public offering. Your market is in Canada, but you could have some private investors through some exception under 144. I forget just what it was, but you would avoid having to register with the SEC because you could have set up a REIT in the first place just in the United States, but they go through this structure. And the primary advantage of doing it this way was to avoid registration with the SEC. I mean, I'm not an expert in this area, but I mean, it's interesting. I've never heard mentioned about this until you started talking about it a while ago, and it makes sense.
Yeah, it's interesting. I would be honest, I haven't seen it sort of from a REIT perspective, but again, the foreign private issuer, I would say it's not so much avoiding. I mean, it's in the act, and it's you're just structuring around being U.S. domestic. But what's interesting about the inversion rules are, and I'm not a tax expert, although Fred and Sanjay and yourself probably could speak to this in a more fulsome manner. But the inversion rules are meant to sort of capture income that companies are trying to divert and take offshore. But in this case, we actually want to be inverted. The rules work in our favor.
Right.
The U.S. cannabis issuer going public, because the principles, and for those listening, the reason it's important is, if you are a principal in a U.S. target and you're going public in a wherever it may be, you actually want to be inverted, because on that disposition of your shares in target for Pubco shares, you have a taxable event. And you want to roll over. And the only way to get that rollover is 78, 74 being treated as inverted. And so
Correct.
But it's actually very important for you to be an inverted taxpayer.
Yes. That's interesting.
I want to get to Daniel Russell, but first, real quick, I see Sanjay, Fred, Daniel. Now you all had your mic on there for a minute. Hot topic. I'll give you want to just real quick express what you were thinking about, and then I can jump over to Mr. Russell.
Yeah, so I'll just put one caveat out there on the inversion. I mean, when we're doing these RTO transactions or these go public in Canada transactions, we want an inversion, right? You want the surrogate foreign corporation. So you want the Canadian parent company to be treated as a US corporation for all purposes of the code. And you can definitely make that happen. My one caveat is just be careful of the state issues there. We've had to do this retroactive. I'd prefer to deal with this planning from the get-go. But California shareholders, for example, right, have a huge issue. California does not respect 78, 74. And therefore, when you're doing that transaction, you could avoid the federal tax on the rollover, but you could have California shareholders have a 13.3% tax. It's marginal, but let's say 13.3% tax on the fair market value of the shares that they receive in the exchange. That could be a deal killer, right? So, so just something to point out.
Yeah, all kinds of stepping stones and things, fences to jump over and whatnot. Thanks for that. Hey, I'm gonna jump over to Daniel real quick. So Daniel's gonna talk to us a little bit about 471C, another another really hot topic in the cannabis arena. Daniel, I'll just prep this a little bit for you. So Section 471C is a code section that says that the accounting rules, which lead to disallowance of deductions under Section 280E. 471C is a small business exception to those rules, and it specifically says those rules don't apply. which is a fascinating question for us tax guys and women out there. What happens when the rules we spend all of our lives learning suddenly don't apply? The IRS has said, well, we still think those rules apply in their guidance, which we could probably talk about for a while as well. But Daniel, I'll ask you this: is 471C, is that appropriate for companies that are looking to go public? And what are some of the problems that might bring up?
Sure. No, I appreciate that. So as you mentioned, 471C is going to be somewhat limited in terms of the size, right? You're going to have to be 25 million in average annual revenues, or if you haven't been around that long, just the years that you have been around, if it's less than 3 years. So as far as going public is concerned, or companies that already are public, there's the size limitation is going to be something that you're going to need to consider. And for that reason, 471C may not end up being something that's possible, or it's going to change the go public conversation. If that size limit is a problem. So I'd start there. We also talked about the multi-state as well, and I think I want to echo that. When you're in one state, it may look one way, but in multiple states, it's definitely going to look different. So in addition to thinking about it at the federal level, it's very important that businesses consider the multi-state aspect of all of this as well, which we haven't touched on a lot, but is definitely an important consideration. And Sanjay mentioned a great point. Just in California alone, it can be a deal killer in certain scenarios. So I'd say that as well. But 471C can make sense. It could make sense for publicly traded companies or companies planning to go publicly traded. But I think, Nick, there's going to have to be a consideration of, it might make sense now. And so, it might be a vehicle that we use in an interim basis, but long term, especially given the size limitation, it's definitely going to have to be something that people consider moving away from. The other thing I would say that 471C is about inventory. So what you're talking about doing, right, is capitalizing your costs instead of deducting them. And so again, long term, you're going to have to think as a business operator considering 471C about, does that methodology make sense long term? Does it fit with what we've got going on and elsewhere? And how does it then combine? We've talked about these cross-border issues, these multi-state issues. How does it combine with all of those considerations? And does it still make sense for us when we think about Canada, Mexico, or whatever other foreign jurisdictions we're dealing with?
So Mark Cohen, a CPA on the East Coast, I think Mark's in maybe Boston, has a question. He says, would you use 471C for a smaller company? I think, Daniel, that seems to be what you're sort of saying. It might be the nice sweet spot here. Is that right?
Yes, certainly. If your average annual gross receipts are under the threshold, the 25 million, then definitely it can be a code section that you'd want to consider. And if you're planning to go over, or if there's some tweaking that you can do to manage the revenue somehow, then yeah, 471C and capitalizing your costs into cost of goods sold under 471C is definitely something that you'd want to think about.
Awesome. Hey, we got one more question here. It's been up there for a little bit. So Philip, I'm sorry I didn't get to it, but I'm getting into it now. I think this one is maybe for Daniel or Sanjay or Fred. Would an American citizen living long-term as a resident of Canada count against the 50% American ownership? Daniel, that seems like that's up your alley.
Yeah, sure. Happy to take it. So this is one of those scenarios where it's facts and circumstances. When someone says living long term, do they mean they winter in Canada or summer in Canada for 6 months and go back to the US? I mean, if you are an American citizen, but you actually are living in Canada as a resident, you would not count against the 50% threshold.
So citizenship matters.
Well, so the 50% test is residency, right? So you could be an American citizen, but if you're actually resident in Canada, you won't count against the 50% threshold in the FBI test.
Jim, we're getting a little towards the 90-minute mark here. I promised everybody we could talk a little bit about REITs. I'm gonna let you take us home, Jim. Take us home.
Well, I'm not going to be able to talk about REITs, but I think we've already touched on it. There's something we haven't touched on, which are SPACs that are mentioned somewhere in all the paper we've been shoving around for the last couple of weeks. A special purpose acquisition company, a SPAC, could end up being, for any U.S. investors, what's called a passive foreign investment company. And if you are a U.S. taxpayer and you end up owning shares of a PIFIC, and it's done on a shareholder by shareholder basis, which SPACs can very often end up, unless you've made special elections, you can end up paying an amount of taxes that is probably more severe than under any other section or provision in the code, except for crimes involving moral turpitude. So you don't want to be involved. You don't want to be caught short with PIVC on a SPAC or anything else. We could talk about
lots of disclosures around those foreign interests here.
Well, yeah, but the disclosures, you have to raise it. If you're going to do tax disclosure, you have to raise it. I'm raising it more now in the context of guys go into these deals and there's a discussion on it. It requires a lot of intention, because guys get caught. I think a lot of people just ignore it, but it's not, it can be very expensive.
Fred, any last words for us there?
Well, with respect to PFICs, they're definitely something that have to be monitored. And the interesting thing about a PFIC, in my mind, is that it takes a collaboration between the shareholder and the company to make that determination and get the information that's needed in order to make a qualified election, so that you don't end up with very adverse effects. So it create for some interesting corporation shareholder dynamics.
Yeah, and a lot of companies just don't want to do it. I don't know why. They don't want to give that information to make a QEF. Now, the other thing is, if you make the QEF, you got to pick, there are costs to it as opposed to just avoiding PIFIC. One would be you have to pick up your income currently, but very severe is you break down the income you pick up currently. It seems to be between ordinary income and capital gain, but you don't break ordinary income down into qualified dividends and other ordinary income. So I think everything is taxed at the ordinary income rate.
Daniel, last words for us?
Yeah, I was just going to say, I think one of the other important things to think about as we navigate all of this is just the changing landscape. It's throughout all of our presentations, right? What we're talking about here today and how to plan for what to do given the current circumstances is only going to really last for a short period of time before it changes again, especially as you're thinking about, international or multinational, multi-state, all the rest of it. And then the other piece of it too is just, getting back we talked at the beginning about some of the IP and the branding, and just getting back to the product. The pure fact of the matter in the US is that once the product becomes federally legal and it's, able to be made available to everyone, there is a long road that needs to be traveled in order to make that access actually meet the demand. I think, the prohibition years ago, or obviously decades ago, it took a long time before all of a sudden things were, readily available. So I just sort of end with that, saying that, all of the different topics we're talking about, I think re-emphasize the need, like you said at the beginning, Nick, for, I'm an accountant, a CPA, telling people you really need to talk to your accountants and CPAs and talk to your attorneys, because this stuff is changing every second. And what's going to work today probably isn't going to work tomorrow. The 471c thing that I talked about is a good example of that, as is a lot of these other topics. So it's just a theme I wanted to point out here at the end.
Yeah, I think, if anything, us all working together on this panel has demonstrated that us lawyers and accountants can get together and play nice in the sandbox. So there you go, right?
100%.
I think that takes us to the end of our program here. If anybody has something they really need to say, I'll go ahead and let you say a last word. But otherwise, I'm just going to say thank you, everyone. Citron Cooperman, Heim Lance, Miller Thompson, Nouth, and Covered Up MGO. Thanks so much for being a part of this program. Look, there's a lot here. There's a lot more to go on this, and I think those of you out there that want to know more, please reach out to the panelists of your choice. And we will be putting out more materials on this topic as we move forward. So stay tuned. It's a very exciting area. And I thank you, everyone, for your participation today. I'm once again honored to be among all of you experts. And I hope you all have a wonderful day. Thanks so much.